and welcome to the Law Chambers, where legal matters are discussed from a Christian perspective. The name is Anita Delight. So last week we had this discussion and we looked at the rights and responsibilities of the employer vis-a-vis the employee. And I've told you this season it's all about these two groups and what we should look out for. We will not tilt too much towards the employee. It's natural to do that. We will try to be as balanced and as fair as possible. So welcome, and tell that friend, tell another friend that we are live and all our social media handles. So please help us spread the word. You see this nice dress I'm wearing here? So the fabric is by Endless Fashion Mall. Endless Fashion Mall. So you can call Samuela or 0243018508. And Rose had this suit for me. She's Mamel's Creation. Mamel's Creation on 0541 809393. You understand? Just mention my name and you get a discount. Right away you get a discount. So last week we looked at all those responsibilities and all those rights. And so today let's look at some of the practices that are deemed fair or unfair according to the Labor Act, according to the Constitution, according to the laws of Ghana. So what are some of the things that an employer does that it will deem as it's a fair practice and it's unfair practice, and the employee as well? I have two very, you know, we try to get the best here. You understand? I'm not bragging, but we try to get the best here. I have two very strong persons here, and they are going to help us have that discussion. Right. So let me first start with Dr. Bennett Wilberg. Dr. Bennett Wilberg is a public administrator with expertise in labor administration, human resource, and employee relation management. If you looked at our flyer, you realize that she's the director of admin and human resource at National Labor Commission. So far we've seen National Labor Commission, National Labor Commission, National Labor. Right now, National Labor Commission herself is here. So we'll ask her a little bit about National Labor Commission before we delve in proper. She teaches courses in leadership and organizational development, strategic human resource, negotiations and conflict resolution, and international relations. She's written so many articles, and she's a local and international consultant. One thing I also love about her is the fact that she specializes in general administration, leadership, and organizational management. This knowledge, she's gotten it with over 12 years of experience in academia. So when we talk about human resource, when we talk about National Labor Commission, Dr. Wilberg you can't take it out of it. Dog, you're welcome.
Thank you very much.
Welcome. We're so honored to have you here, and we are grateful. So, Dog, let's discuss a little bit about National Labor Commission. Tell us a little bit about National Labor Commission.
All right, thank you very much. Okay, so the National Labor Commission is established under the Labor Act 2003, Access 51, specifically Section 135, as an independent arbiter in labor and industrial dispute resolution. The commission is made up of we call them social partners when we talk about labor or industrial relations. That is government as an employer, employers organization, and organized labor. And when I say government as an employer, because when we talk about labor relations, government plays a dual role. Government as a policy maker and government as an employer. So government's representation on the commission is as government as an employer, right? And these members of the commission is a tripartite composition, which I said, government as an employer, organized labor, and employers organization. They have equal representation. Okay. And a chairman who is nominated by organized labor and employers. So we have a 7-member commission who are appointed by the president. And their function is among others to facilitate the settlement of industrial disputes, to settle industrial disputes, to maintain a peaceful industrial relations atmosphere, and so on and so forth. So basically that is about the commission.
What would you say if someone says that the commission is a toothless bulldog? What would be your reaction?
Wow.
Actually, someone said the same thing here. I'm like,
what would be the basis that the commission
the commission can bite?
Yes, the commission can bite. You see, when the commission in its adjudicating, in performing its adjudicating role, the commission has the powers of a high court, and it is not subject to the control or authority of anybody or persons, right? And the decisions of the commission are as if the decision has been made by the High Court, right? What the commission doesn't have, because in law the commission is an inferior tribunal, right? So what the commission doesn't have is a compelling power as such. So when the commission makes a decision or gives an order and the party does not comply, the commission goes to the High Court to seek the power of the High Court to enforce. But if you also are aggrieved by the decision of the commission, you go to the Court of Appeal. You don't go to the High Court. And so perhaps the person has not really researched to know how the decisions, the effect of the decisions of the commission. That is why they would say, the person would say that the commission is a toothless bulldog. Because when it comes to appearances before the commission, that's why I started by explaining government's role. Because the commission subpoenas government authorities to appear before it. Minister of Finance, Minister of Education. And when you hear all these strikes on the air and all that, we have strong representations from these people appearing before the commission as parties to the dispute. So I don't see the basis why anybody would say the commission is a toothless bulldog.
Thank you so much. Thank you so much, Doc. You see why she's here. We're going to have a very interesting discussion. So let me go to our next guest, Mr. Senyo M. Ajabin. The M stands for?
Melvin.
Melvin.
I normally don't disclose it.
Yes, because he said M and I asked him. Melvin. Okay, see, Mr. Senyo Melvin Ajabin.
Yes.
That's a nice name. Mr. Ajabin is a labor consultant and mediator arbitrator. He's listed with the National Labor Commission. He's a trained non-executive director and a member of the Institute of Directors, Ghana. He specializes, of course, in employment relations, measures, workplace investigations, and employment law. He has over 20 years of experience, and when it comes to the public sector, the NGO sector, he has a very vast there. He also studied mineral processing and metallurgical engineering from K University. Hey, now how did he get to labor? He also read conflict, peace, and security studies at the master's level. One thing I love about him is also he's written 2 books. One is Career Toolkit for Successful Job Hunting, and one is the 51 Rules for the Perfect Gentleman. I think every guy should go and pick one of that. We need a lot of gentlemen in our country now. Presently, Senyo is the country director of WBHO Construction Ghana, a multinational civil and mining construction firm. He's a certified senior professional in human resources, SPHR USA. So, you're welcome.
Thank you.
I hope you're good.
I'm okay.
How the mining and then labor and then how you imagine those now?
Well, I think after school and after national service, I found myself trying to, settle in the workplace, and the mining sector at the time was going through turbulence, so we didn't get opportunities quickly. I went into banking for a bit. But I settled down in dispute resolution and specialized in workplace disputes. So it's the workplace disputes that took me to human resources, yes.
Well, that's interesting. You're welcome.
Thank you.
You're welcome. And of course, my usual partner in crime. That's Ata Nyameche. Ata is working with the sign language for us, and we are so grateful to him. So let's delve in a bit. When we talk about the employer, let's refresh our memories here, right? When we talk about the employer, the employee, who are they? What's the relationship? When it comes to mind, what's the first thing that we should think about?
Okay, so an employee is a person or a worker who works under a contract of service, whether fixed term, temporary, or casual. Right. And an employer is a person who employs a worker under a contract of service. And when I say contract of service, it means that there is an employment relationship. That's all. There is an employment relationship, which is different from contract for service. So there is an employment relationship. The person works under the instructions and direction out for want of the employer. So you have job description and all that. So that's then create the employment relationship.
The law normally uses the word worker, and a lot of people then ask what the difference between worker and employee is. They are basically the same and interchangeable, but it's assumed that the employee is in a more formalized environment of work with a structured contract of service, and the worker may be anybody who is employed to work under any condition or term. So the worker then becomes a more generalized, terminology that is used to represent someone who's been employed to do a particular job. Yeah.
Okay. So well, in this relationship, what then can be termed to be fair or unfair? So first of all, what's the fair practice? What's unfair practice?
When you talk about fairness in an employment relationship, you are talking about issues of non-discrimination, equal pay for equal work, fair treatment of all workers, that you will not discriminate on grounds of gender, religion, and all that. So those are some of the examples of fairness in the employment relationship, fair treatment in employment relationship.
And basically, any action that breaches the contract of employment or the employment relationship becomes an unfair practice within the context of the relationship. But because your title was unfair labor practice, maybe we should, for technical people who may be listening, we should differentiate between an unfair practice in an employment relationship and what the law typifies as an unfair labor practice. And that would be basically in accordance with Section 127 of the law, and that is about discrimination on the basis of either unionization or non-unionization or anything to do with an employer's interference in union activities. So the law classifies that as unfair labor practice. But of course, there are other unfair practices that are within the context of the employment relationship.
So now let's start with the one in the law. So what are some of them? Let's delve a little bit in it. The one in respect to the act itself.
Okay, maybe I'll give one and then Doc would. So basically, one of the major differences between the act as we practice now and the previous one is that people became automatically part of a union when they joined an organization. But the Labor Act of 2003 stopped that and ensured that the joining of union was by choice, and it was based on the free will of the person. So a person chose or chooses to join or not to join. Now, if under any circumstance, anybody forces the employee to join or to be part of the union or not to be part of it, or to incentivize them not to form or to join or to interfere in any way, then that would be one major unfair labor practice which can then be dealt with in accordance with law.
So what we are saying then is that if I'm in a workplace and there's a union, I can join if I wish to, and if I don't wish to, I'll not join.
Yes.
So now let's be a little bit practical here. Sometimes you're not part of it, and then when they go and negotiate, they will tell you, because you are not part, we'll not give you some of the money. What's your take on that? I want to push you to the corner. I'll come to Doug.
Okay. No, you see, now the law allows, for example, that where agreements are reached for classes of workers or a class of workers under a collective agreement, okay, as negotiated between the union and the employer, then the conditions can be transferred onto other similar classes of workers within the organization. And indeed, we have the basic principle for equal work for equal pay. So if you want to bring, a rational, fair, transparent, kind of standardized conditions of employment, then when negotiations are held, the outcomes of the negotiations would normally be extended onto other employees. This doesn't make unions in Ghana too happy, but as I always say, it means that it calls upon them to to offer other services beyond just negotiating conditions of service for the workers, and serve the workers as their true representatives within the labor relation.
Yes, and then pushing you further. You see, yes, it's true. You can join voluntarily, and if you don't join, every entitlement thereof, you're also entitled to it. But then again, when you're entitled to it, they'll tell you, then let me take this percentage off. So because we negotiated, and you are getting it, then I'm taking 5% of your. Is that allowed? Well,
there's no contract, so it will be subject to the consent of the employee if they want to show appreciation. Yes, if they don't consent, then they cannot be forced to contribute.
We have some unions doing that. What's the way forward?
Like I said, I think it's about the consent of the employee, and if the employee agrees. If the employee does not agree and it is deducted, then it becomes another unfair practice for under deductions that are not permitted, right? So we have permitted deductions and prohibited deductions. So it becomes a prohibited deductions for which the employee can go to the National Labour Commission and complain to the Commission to have that deduction reversed.
So, Doug, have you ever come across such a case?
So we've had a couple of cases like that where when we talk about deductions, in fact, before you can even say you are deducting somebody's money as union dues, the person should have signed onto the union. Today, you can't just automatically extend unionism to other classes, like I said. Let me just put it into context. So you have drivers who qualify to be a union. Then I'm employed as a driver. Then automatically you start deducting union dues because my class qualifies to be the union. That would be wrong, because that would be unlawful. I would say unlawful, because first of all, I have to consent to be a member of the union by filling option forms, which would also authorize the employer to deduct union dues. So you can't just deduct. Again, like I said, if you go privately and do those discussions, but when we want to talk about what the law allows, it is not for you, the union, even to say that I have negotiated, and so and you are not a member of the union, but you are enjoying, because you, the union, you have responsibilities, rights. Remember, rights and responsibilities are prescribed under the law. And the employer has a fundamental responsibility to offer equal pay for equal work. Right. And then the right to join or form unions is also right that is granted. So I can decide to join, I can decide not to join. But if I have others who have joined, who who are being paid monies, and I am being paid differently, that also is not acceptable on the law, because in law, because it should be equal pay for equal work. So the union doesn't even have the right to come and negotiate with me to say that, why is it that you are not a member of the union, we have negotiated and you are enjoying. It is the employer's duty to pay. Remember, to pay workers is employer's duty. Your responsibility is to negotiate for the class of workers that belong to the union. It is the employer's duty to ensure that he also ensures fair treatment. So that is the law. So we have situations even where a group of workers said, look, we have been employed and there's this union there and we have not signed on to the union, yet dues are being deducted. Those are unlawful. That's a government agency. Those are unlawful deductions, because we have not authorized the deductions. So the matter was gone into, and then in fact the decision was that it was unlawful for the union to be making those deductions when the workers have not opted to join the union.
Yes.
So it doesn't matter whether you are negotiating for a class of workers or not. It is not your responsibility to pay them. It is the employer's responsibility to pay them, and that responsibility is in law. So that is it.
I joined an organization.
It's serious, because when you join an organization, it's automatic. The first month you realize that they've started.
No, I joined an organization once, and then I realized that they had started deducting. And so I wrote to the union, reminded them that I have not opted to join the union, and that such deductions should cease. But then I donated what they had deducted already to the good of the union as support for them. So yes, an employee can also assert themselves, if they truly do not want to be part of the union, to opt out where the deductions start.
But then aren't you putting yourself in a position where you are going against the union? Because frankly speaking, there's a whole organization of employees, and you single yourself out, and you're saying don't do this, don't do this. Aren't you putting yourself in harm's way in any shape or form?
I don't think so. I mean, it's a right that you can choose to exercise or not to exercise. Right. The right to associate is granted by the Constitution and even by the International Labour Organization Convention. And so it's a right that you have to exercise. So I don't think you'll be going against the union if you decide that you would not be part of the union. You know, when I joined the service in the late 80s, I remember at that time we had an association, that those days were under the old law. You had an association. Automatically, when you join, deductions are made. You know, but now the law is saying you can't do that. You can't do that. The people will have to opt to be part of the union before you start making the deductions. Because in fact, if they bring a case against you, you have to actually prove that they authorized the deductions. And before the employer deducts the union dues, the employer must also make sure that he has seen option forms and authority to deduct union dues. So the employer doesn't have to just automatically start making deductions when authority has not been granted.
Wow.
Yeah.
And the protection of the employee by the law goes beyond the services that the union offers. So the employee can seek protection under the National Labour Commission directly, under a consultant, under a legal, a lawyer or legal representative, or anybody of competent stature who understands how to advocate for the rights of the employee. And so just saying that, well, I do not want to be represented by the union does not expose you too much to any form of, to the extent that you are not protected under the law. So it's a choice, and it's a very wide choice. And of course, there could be multiple unions in the organization. And you could choose that I'll not be part of this, but I'll be part of that. Yes.
Okay. So I think I'm so fixated on the union because it seemed like it's something automatic. You join the organization, then you join the union, and they start deducting, and they send they send an email and tell you that if you refuse to join, and then they'll deduct this amount of money from. I'm like, where is this coming from? Okay, so Doc, let's go to that. I know we'll come there, but let's go. So apart from unfair labor practice in terms of the unionization, let's now look at not in terms of the law, but in terms of the relationship between the two. What other ones are there?
So when we talk about unfair labor practice, even there's one important issue that has to be looked at. You cannot, you see, there have been situations where you are even engaged in negotiations, okay? And there are threats issued. Accept this, or that's an unfair labor practice. You can't be negotiating and be wearing red bands. You have not gone on strike. You have not made a declaration, right? But all of you suddenly you are in red band. Let me give you a typical example. There was a situation like that, and they were negotiating. They felt that the union felt that the negotiations were protracted. And if you feel like that, there's a provision under the law where you have to seek redress, that the other party is delaying the negotiations and all that. But what they sought to do was for all of them to wear red ties and for all the ladies to have red hankies or whatever in their... And the employer felt intimidated. So the employer files a complaint and says that, look, there's unfair labor practice going on in my organization. And all of we come to office on the Monday, and all the workers have a touch of red. And so they were invited, and then the union was like, oh, it's just a coincidence. And it wasn't Valentine also, for you to say that it's Valentine. So as the matters were probed further, really, it was deliberate. And what they said, it was interesting, they were like, we are wailing. So clearly. So that's an unfair labor practice. So a declaration was made. So those are some of the instances of unfair labor practice that you can't be intimidating or issuing threats, like accept this, employer saying accept this percentage, or I will declare a redundancy and all that. Yeah. It means that you are kind of coercing them into agreement. So where you make any attempt to coerce somebody during the negotiation of a collective agreement, or during collective bargaining, the collective bargaining process, that's also unfair labor practice.
That's interesting. That's interesting. Okay, so can we look at other?
Okay.
So generally, for unfair labor practice, another one would be where, apart from threats, there are all these what we call strikes or industrial actions or semblances of those. And chief among them is what we call the work to rule, where workers work very slowly. You know, under normal circumstances, there's a lot of activity, but everything gets slowed down and productivity slows down to almost zero. And the employer then becomes very frustrated because it's not getting its production numbers. And that would constitute an unfair labor practice, because it would be seen as an unlawful industrial or illegal industrial action.
So who are usually the perpetrators? Usually when we think of unfair labor practice, the first person that comes to mind is the employer. The employer always buys unfair. But from what we've discussed, it's possible for the employee to act so. But then, who is the main perpetrator? Will you want to shift the blame somewhere?
I don't think there's a main perpetrator. It depends on the relationship and at what stage, for example, the relationship is. And it's also sometimes sways along the sides of where power, plays within the relationship. So when the power swings in a particular direction and that power is abused, then of course it becomes an unfair practice within the relationship as well. So normally you would have employers having more of the power because they are the agents of payment, and so sometimes they result in all manner of actions that seek not to be in accordance with the law. But in certain instances, Doc will tell you that there are certain very stubborn group of workers that would just continue to frustrate the work of an employer. They are intransigent, they are not understanding, they are not compromising. Difficult. Under those circumstances, then of course, you can say that the workers then would be the ones that are creating the problem. And I'm happy to say that I've been part of, processes at the National Labour Commission where employees have been called out and instructed and told to go back and stop what they are doing and to do the right thing. And especially, of course, even when they go on unlawful strike, they are always given directives to go back and do the right thing. And so yes, it swings, but it depends on the relationship, I think.
So far, no, you're discussing a break. Me away a break near summer back. So far, you're discussing a break. Now, once you're discussing last I discussed, we say, and National Labour Commission, you could be a mom boy, and then Doc Amaya who say, National Labour Commission or to me as a corner honum, now the Wasam could dine or wait me up for or to me to say High Court and Casa. What I say, inti se wo de asem kondai na obetimi aboa na oboa obetimi de akokota ma asem ho no ka etia nipa na wodi webumra no obetimi aforce nipa no through the court ama nipa na ye ade eje se oye inti se wadwemo se asem okoso wo me organization National Labour Commission and National Labour Commission ye na nkofo ka se wo nhye da enye no kre alizu de kohona kwa trial mo hwe mentiti nkofo do kaka twen ko na ko trial mo hwe na hu so bebo yes am ebo nkomo no so no yes an ka sesen oni obi practices bi o hwan na enche se oye employer ni employee enche se oye juma ba bi na union bi o ha utimi join ni union no umpese o join ni union na I men join it yintimi force o say join ni union no opa men join it na one join so a was no one ka say so one join a ye scanner de be ma ye yakete na ebetum no ye tu de mu a ye beyi obetua ye ka if say na ye ko negotiate enye no kre one person join union na men join it but no mu benye bia no wo benye bi but disadvantage ne say won say mu ye group na mo ko a easy as some be kon say won ko an be kon but say won ko person wo ye solo a say na Mr. Senior Kai no it's wetimi aye. Oh yeah, apart from union no, your lawyers or your labor consultants or National Labour Commission or meboa. What I say? In 2% or join the union now, ain't me for some own join it. But or join it so a meboa. Na as some ya Keniano, the top fan pan say, oh ye juma or baby, ye may be or why and just so ye may be or just so ye. Na act na kache, ye may be and just so ye, and the aka union name yamano. All things being equal, no. After this short commercial break, see Babaka, you better share the other side of it as well. When you saw questions in the Albert Media by a Facebook page, on the Koha, you better come on a bisa questions. I'm a dog and then Mr. Senior, answer mine. In time for this short commercial break, we'll be right back.
Are you a Ghanaian or resident of Ghana? Are you 30 years and below? Are you a startup, micro or small business owner wanting to scale up your business? Then apply for the Pitch 2024. Join the ranks of burgeoning startups from all across Ghana. Follow your dreams. Be bold and pitch to win a stake in the 100,000 Ghana cedis needed to unlock your startup's potential. Apply now with 100 Ghana cedis at www.thepitchghana.com.
The Pitch is powered by Hope Channel Ghana in partnership with Seed Spring Network and sponsored by Heritage Cooperative Fund, National Entrepreneurship and Innovation Program, and our donors.
Immerse yourselves in the harmonies that uplift the soul as Valley View University Choir presents Todar 2024. Come experience a concert that promises to be exceptional, showcasing a diverse range of musical pieces that celebrate artistic expression, gratitude, and commitment to God. It will be a day filled with music, worship, and praise. So save the date, 20th April 2024 at 4 p.m. Venue is at International Palace Church, Medina Ridge Junction. Come with your families, friends, and loved ones, and let's make a joyful noise together. See you there.
Welcome back. Welcome back. So I just want to deal with some of the questions that are in, and then we'll move to the next person who said, "Good evening, madam. I have worked with a government agency for the past 5.5 years. I started as a NAPCO personnel and now contract staff. After 4 years of NAPCO, we have been given contracts on several instances. First, I was given 3 months, second, 1 month, third, 3 months, another 8 months, and now doing 6 months. What does the law say about my situation?" That is smiling.
So, if I understand, he or she has been offered a fixed-term contract. Okay. And a fixed-term contract is a form of contract which is recognized in law. And so, until you actually, if you ask about what do we say about your situation, until you have the issues clearly before you to see that maybe there's an abuse somewhere, you can't say that it's not right for the employer to offer fixed-term contract, because fixed-term contract is a form of contract.
Okay. So what are some situations where this kind of contract will be deemed to be an abuse?
So, for example, take the nature of the job. Mm-hmm. The nature of the job is clearly continuous. Take, for example, you have 2 employees sitting, say, in a bank, okay, as tellers. One is a permanent worker, and then they do the same thing. One is a permanent worker, and then the other has
sorry.
Yes. So the other one has a fixed term contract. So one is permanent, one is fixed term, right? And you keep renewing the fixed term contract while the other one has a permanent contract. This clearly is discrimination because they do the same thing. So when you go into the nature of the job, you are going to see that, okay, the employer has to explain why 2 people are doing the same thing, employed on the same day, and being in the company for the same time, but one is permanent and one is on that kind of contract. So there must be some explanation to that. So that can then be queried under the principles of fairness. Okay. So that's one of the situations. Another one, another situation could be that you have a contract that expires, a fixed term contract expires. Nothing is told to the employee. And then it continues for some time, say 2 months, 3 months, 4 months, 6 months, 7 months, sometimes 2 years, 3 years. And it's that same fixed term contract that continues. Then, of course, it is no longer a fixed term contract because it expired and there's now an open employment relationship that is not capped by any contract. So that then would mean that the situation would show that the contract between the two parties is not fixed term, but it is permanent, and so it will be seen as such. So depending on the situation within which the renewals are occurring. I'll give you another example. Where a contract has the same terms, but they only change the dates upon expiration. And then this has gone on maybe 3 months after 3 months, 6 months after 6 months for say 11 years. And that's happened, you know. Then the contract is terminated and the person says, no, I'm not, you know, a fixed term employee, but I am a continuous employee. They line up all those contracts, and the only things they see is the change of the dates. It may call the ethics of the situation into question, and then it can be said that that then is not a fair way of treating an employee, because it is clearly a continuous contract of employment that an employer decides to break. Maybe Doc may want to add.
Yes. So you see, if you, in fact, we cannot do away with the fact that there are some abuses in the system, because if you want to clearly go by the definition of what fixed term contract or circumstances that should warrant fixed term contract, it's more of jobs that are not continuous in nature. But for some reason, some people would say maybe it's a project and it's in phases, and they are not sure whether the next, because it's been, they are getting funding for it, so the next fund would come immediately and all that. So under those circumstances where fixed term contract is granted, that is understandable. But you have situations where you could see that the very nature of the job itself is permanent, yet fixed term contract is being granted. Now, but the issue also is that at what point would you say that you are being exploited, or your rights are being, you know, because it's an offer and acceptance, right? And the offer is given to you, and you accept, you sign onto it, and so, like he said, the circumstances will determine whether there's exploitation or not, because there, for example, you give a fixed term contract, you terminate the contract before its expiration without reasoning and all that. If in some cases decisions have been that is unfair termination, so pay the unexpired part of the contract. So you see, the way the contract itself is crafted would determine whether there's been unfairness or not. So in this particular instance, yes, we've explained that fixed term contract is a form of contract, and if you want to say that you feel exploited because there's exploitation of labor, yes, or disguised form of employment relationships and all that, which ILO has discussed and all. So it will depend on the circumstances of the situation and the circumstances of the particular job. Okay, like the example that I give, if the job itself you are not sure of continuity, so you just give contracts based on the resources that are available to do the job.
Okay, so let me be the devil's advocate. I like doing that. We all know NAPCO, right? We are all in this country. We know NAPCO. We know the young men and women who are working there. We know the terms of. So the little we know about it, do we really believe there's exploitation in there in the form of unfair labor practice going on?
I wouldn't think so. The NAPCO module is such that it operates on the basis of availability of job opportunities. So if an organization notifies the NAPCO head office that I have a 3-month job available, and you fit that kind of you fit that kind of role, you are sent there, you finish that, and it expires, then clearly you no longer have a job. But then NAPCO then tells you that, oh, there's another one in another place that is say 8 months or 7 months, so you are given a contract to go there. The module operates this way so that people will continue to be given job opportunities after their initial 3-year or so NAPCO in traineeship, you know. So I don't think that within the NAPCO concept it would be seen as exploitation, because it runs on the basis of availability of job opportunities from different entities within the public and the private sector.
Okay. And so that's what I was going to. So if you look at it, most of them are in the public sector.
Yes.
And they have one employer, that is the government.
Yes.
And so if here 6 months, here 7 months, here 10 months, here 9 months, the same employer.
Let's explain government as
an employer.
Okay. So government as an employer is controlled by central government, which is a policy maker. But then government then has, call it arms, through and works through its agencies, you know, ministries, departments, agencies, and also the public sector institutions. So they are all together seen as government. But each entity have their own regulations that regulate them, their mandates of business, and so on and so forth. So when they act as public sector, they act as government, but they are an entity that is governed, that have a board, they have a governance structure. So each of those institutions would make their own independent decisions.
Okay.
Yeah.
So then that will not fly. That means then what about it being I know, right? What about it being the same organization? So your employee 6 months, 3 months, 4 months, the same role, the same organization. Can there be the possibility of?
You see, when you talk about organizations, and especially the public service, every organization has a ceiling with the establishment list or establishment post. Right. And because if you don't have that, you just be recruiting. Okay. And so these establishment posts have been approved by the Public Services Commission. Right. And you cannot exceed that establishment post, because you can't, in the first place, you can't even employ if you do not have a clearance to employ. But within the government organization, there could be a project. There could be a project within the organization where workers will be needed. I think what the whole concept of this NAPCO is to ensure that, and which Senior rightly said, that people get jobs. Okay, so within an organization, a public service organization, there's this project and it's for this duration, or that this work is for this duration. These workers are given the opportunity to perform those jobs. Again, if it's a project has a lifespan, right? And the project can be in phases. Okay, so you can have a first phase of 6 months, or a first phase of 1 year, or a first phase of 2 years. Then you have a second phase, and so as it is phased, because you cannot remember, if you employ somebody on a continuous service, whether there's work, because when you are a worker, you go to work, whether you are given work or not, you are supposed to be paid. And so here you are, you know that you have this 2-year project, yet you have employed people on a continuous basis. The project ends, there's no money, but you have to pay them. So I want to believe that, you see, before you can talk about some of these things into details and say it is right or wrong, the context would have to be known and looked at, and the kind of employment relate or the kind of job would also have to be looked at. So because I think what he just gave a general statement by saying I am being given 1 month, 3 months, and all that. The context will depend as to whether what is being done is right or wrong. So if we sit here and we are to say whether something is right or wrong, that will be very difficult, because the context would have to be known. If it's a project, if it is a program within a specific time, you don't expect to be given.
Yes. Okay. So another question is from Stella. Stella, I've read your question twice, and I'm a little bit. Okay, so she's saying that she used to join an association, right, in her workplace, and the association, they've been, apart from the general dues that is paid, they pay dues down there as well, and they are supposed to pay in terms of funerals. They're supposed to make some payment. When it got to her turn, she didn't get anything, and so she wanted to opt out. And they told her if she wants to opt out, she's supposed to pay an amount. I hope I'm getting your question. An amount before she can opt out.
You know, when you talk about associate, you see, it's important for us to put things into proper perspective.
Yeah.
Before you qualify to be a union, there's a process to go through. Register as a body corporate with the Registrar General's Department, go to the Chief Labour Officer, who is the Registrar of Trade Unions, and be certified as a trade union. That is different from an association.
Okay.
Right. That is completely different from an association. So you could have a union, you could have an association. Okay. An association, you decide the same way you decide to join the union. And unions, unions are properly regulated, as it were, because you have constitution and all these things, because unions are supervised by the Chief Labour Officer, by the Labour Department. So there's a structure and form of unions. So that is different. But if you join an association, I mean, it has its, if I decide to go and join an association, and it's my free will to join that association. So when you want to talk about some abuses there, that one is not what we are talking about. We are talking in the context of a trade union.
Okay.
Because everything that is granted in trade union is negotiated. And if they have other benefits, they could have other benefits apart from what they've negotiated with the employer as trade unions. That is separate. So it's better for her to put it into proper context.
So Doc, let's look at it in the two contexts. So let's say it's a union, and this has happened within a union. Is it possible, and should it be?
That's okay.
Yes, I mean, what I would say, to this question is that you need to know the rules of an organization before you join. Because, for example, you said if it's a union, unions have constitutions, and when you sign on to the constitutions, there are provisions for exit. So a number of union constitutions I've seen in Ghana would be that you have to give a notice of about 6 months to the union before you exit. That is 6 months of your monthly contribution until you exit. And that is the constitutional provision, and that binds you. And the employer is going to make sure that that is respected. If it is a general association, you have the constitutional right to join any association, any legal association of your choice. And once you join the association, for example, like any association or any group of organizations like a church, like an old students association, and so on and so forth, then you are bound by their rules. So I would say that you need to know the rules, because there's free will. You can run into something, then that becomes a disadvantage to you. So you need to really understand the association you want to join or to be part of, understand the rules that regulate it. If it's a union, you need to understand the union constitution and all the provisions and the benefits to you before you opt to join. And when you join, because when you join, you'll be bound by the rules of that entity.
But have you ever heard of a union where someone is exiting and there's money paid, or has that ever come to your attention?
No, you just have to give the notice. Indeed, a number of employees sometimes don't even give the notice, and they just stop being part of the union. But this is where some of the unions then go to the employer and say that, okay, this employee is exiting, but this is the exit provisions, and so you need to continue to deduct up to this number of months or number of whatever before the employee can be seen as no longer part of the union.
Okay, so just to add to it, you know, I think that's a duty of the unions to actually educate the members. But you see, again, there have been cases where employers have just stopped deducting union dues because they claim the a worker has come to it to say that I don't want to be part of the union. And the union has brought a case. The union has brought a case because, and it rightly said so, when you freely, voluntarily join a union or association, you are bound by the rules and regulations of the association. And so, if it happens that you have to give 3 months notice before you exit, and the employer also, because you have just told the employer I want to exit, the employer stops, the employer will be ordered to comply with that in accordance with the constitution of the union. So that is it. Once there's a free will, there's a free will to join or not to join, but as soon as you join, you are bound by the rules and regulations of the union or the association. But in this context, we're talking about union, yeah.
And we have Belinda. Belinda is saying, "I'm loving the show." Thank you, Belinda. Please share for us. Okay, she says she knows Doc, and she's very much into what Doc is saying. So her question is, I'm currently working, and it seems as if they will be terminating. Okay, it seems more of a redundancy. What should she do? I think we are not doing redundancy. Redundancy will be next 3 weeks. So, but I don't know if you want to touch on a bit, but we'll be doing redundancy proper next 3 weeks. So a little bit. What should she do? It's as if they are going to be laid off. She knows they're going to be laid off, and it seems as if they will not get any benefit whatsoever.
She's assuming.
She's assuming. So what's a strategic plan she should put in place?
No, she shouldn't put any plan in place for me, really, because redundancy is governed by Section 65 of the law. When the employer contemplates, the employer will have to notify the chief labor officer 3 months before the contemplated changes, and the workers are also notified, or the union consent. In fact, I always say that, you see, you negotiate your way into the employment, and when it is time for you to exit the employment, you again negotiate your way out of it. When it comes to redundancy, it is whether you belong to a union or not, the employer is obliged under the law to have the negotiation with you. So until you are told that you are going to be declared redundant, and the process, whether it's flouted or not flouted, then you want to raise an issue. But if she wants to be educated on a brief education on the redundancy process, so that's what I've just said, that notify the chief labor officer, the employer would have to inform the workers, negotiate with them, negotiate. It did not say just offer a package, it says negotiate with them. When you negotiate with them and you agree, that is it. If you are unable to agree on the package, that is where you bring it to Labor Commission. Okay. And so basically, that is the process of the redundancy. I don't know whether she's been told. She's just thinking that she'll be part of it, assuming that she'll be part of the redundancy. She should just prepare
to negotiate.
She should just prepare to negotiate
her conditions.
Yeah, that's
yes. And our time is almost up. And Ata Kwachewa says, I'm watching and I'm loving it. Kwejo Japan Evans is saying, Anita, thanks for this show. We are most grateful. Fifi Samieboa, Anita, I love this. Thank you so much for loving it. So your final words. My time is up. And I know they'll beat me up.
So basically everything starts with a contract of employment. And workers need to understand what they sign. And so they should always seek help. The Labour Commission is always available to help them to understand these issues. That is what they are established for.
The Labour Commission
Yes,
itself.
they can just walk into the Labour Commission. They have any questions, any clarifications. But my point is, before they sign any contract of employment, they should seek help so that they know what they are going into. And then that would make a lot of difference in how they manage themselves within the employment relationship.
Okay, so what I would say is that every worker in this country should get a copy of the Labour Act 2003 Access 51, because that is your Bible. And it is written in a user-friendly language that is so easy to understand. You don't have the thou and the knoweth and the things in it. And read. If you don't understand, like I said, get somebody to explain to you, so that when you are in, before you get into the employment, or when you are in the relationship, you know what your rights and responsibilities are, what you have to do and what you don't have to do.
Thank you so much. Thank you so much. And our time is really up. And I hope you did enjoy today's session as well. As usual, please, 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 please again. I did I so far and see and also say, on say only be ye juma na only ye juma. You say o ye juma o do we need that now ye juma no. As I say, kofu we be bisa question say nti ye me di na ye me we are there na menye me association we. See I can be association to me join it open on join. But sana dog aka no. O ye juma no only be ye juma per Labour Act no. O we di enye den. Onti asia sana Mr. Senyo aka no. Labour Commission, you better try to get say Labour Commission, only omo ultimate come office, only omo ko bon komo a omo contract now on say now we need to be the lawyer with the kohono because at the end of the day, no, sir, we know documents on the man, no, and never having relationship, no. So what I say, inti ye boy who see only be I said, and because say, 1992 Constitution, no, and the ending kakra about with the abeti asekakwa, but secondly, no. Labour Act and so not to be. So to be employee and employer now will be not already within kakra kra. You bet me a bow. What I say. Inti please, if you want, you see how nice my material is. Please go to LS Fashion Mall 0243 018 508. Samola, she will help with. And Mamel's creation. She's so this nice. I wish I could stand up. It's so beautiful. I'm loving my dress. Rose on 0541 809393. We'll come your way same time next week, 6:30. Please stay safe and adieu.